Good day everyone, I am John Mardinoy. Today I'm going to discuss Lesson 1 Evidence. And there are three definitions of evidence. Number 1. Evidence in its legal definition is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Number 2. Evidence also refers to any material which tends to pursue the port of the truth or probability of some fact alleged or asserted before it. There are three types of evidence, namely oral testimony, documentary, real and circumstantial evidence. Number 3. Evidence refers to all means by which any alleged matter of fact whose truth is investigated at judicial trial is established or disapproved. And before you complain, look for evidence first that proves that he or she committed the crime. 3 forms of evidence in criminal investigation. Physical evidence. It refers to physical object used as evidence which is obtained through searches at the scene of the crime. And there are the examples. A. Firearms and fired ammunitions. B. Knife or bolo. C. Blood, semen, saliva, human or animal. Biological samples. D. Finger and footprints. E. Tool marks and tire tracks. And F. Hairs, fibers, glass, paint, and other trace evidence. A. Category of physical evidence. Number 1. Associative evidence. These are pieces of evidence which links a person to a crime. The offender may leave clues at the scene such as weapon, tools, garments, fingerprints, or foot impression. Broken headlights glass found at the crime scene in hit and run, wearing apparel of the offender and other articles of value may be recovered at the rape scene. Number 2. Tracing evidence. These are evidence that may assist the investigator in locating the suspect. Aircraft of ship manifest, physician clinic record showing medical treatment of suspect for injuries sustained in the encounter, blood stains recovered from the area traversed by the wounded suspect in the infer direction of the movement are examples of tracing evidence. B. Biological and transient evidence. Biological evidence. It refers to evidence that is commonly recovered in crime scenes. Each biological evidence has a unique importance and its own probative value. It is an evidence that can be tested through DNA mapping and other profiling methods. It consists of bodily fluids and tissues that has particular significance since DNA analysis can be conducted in many instances. Some biological evidence that has DNA include blood, saliva, semen, slop, skin cells, hair, urine, and fecal materials. Number 2. Transient transient evidence. It refers to evidence that by its very nature can be easily changed or lost. For instance, transient evidence includes temperature, odor, blood in the rain, and some biological and physical phenomenon. It indicates elements of physical evidence that might be expected to degrade or disappear within a particular time frame. It will lose its evidentiary value if not preserved and protected. So, what is corpus delicti? It is a Latin term for the body of the crime. It is the legal term used to describe physical or material evidence that a crime has been committed, such as the corpse of a murder victim or the clean of a thatched building. It is used to refer to the underlying principle that without evidence of a crime having been committed, it would be unjust to convict someone. C. Other specific kinds of physical evidence. Number 1. Soil. This consists of organic natural materials such as rocks, minerals, and decomposing plant, and may also contain man-made materials such as bricks, concrete, glass, or paint. The densities of soil samples are analyzed via chemicals that separate the particles that compress the soil. If pattern of separation is similar, it indicates a match. The common scientific technique of analysis soil is called the density gradient tube. Number 2, paint. Paint is pigmented polymer that is applied that adheres to various surfaces. It is possible to examine microscopically the color and shape of paint strips or other samples, as well as to determine through the use of gas chromatography. Tool mark. Number 3, tool mark. Tool mark is any mark that is created when an instrument has contact with another surface. The mark left by the tool may indicate the type of tool, the size of tool, and even the skill of the perpetrator. Number 4, shoe paints and impressions. Shoe paints are created when material from the bottom of shoes is transferred to another surface, leaving an outline of the bottom of the shoe. Shoe impressions are often left in soft material such as mud, snow, and reveal the outline of the shoe or tire. Number 5, videotape evidence. Videotape is potentially extremely powerful form evidence. If a crime captured on video, there may be little doubt about who committed the crime. Number 6, dental evidence. The two primary kinds of dental evidence are dental identification and bite marks. In both instances, the fact that individual has a unique set of teeth in terms of form, arrangement, dental work, and bite makes dental evidence powerful form of criminal evidence. The physical characteristics of bite marks and dental identification consist of the distance between teeth, the shape of and mouth of bite, teeth alignment, teeth shape, missing teeth, and wear patterns of the teeth. Number 7. Computer and other electronic evidence. Computers, cellular phones, and personal digital assistants may provide a wealth of information regarding communication, schedules, and criminal behaviors, and therefore are potentially valuable sources of evidence in criminal investigations. Examination of electronic hardware is quite technical in nature and, if not properly performed, can result in lost evidence. Testimonial evidence. It is also known as eyewitness testimony of communicative evidence. It is the product of interview and interrogation from which witness smell, hear, taste, and touch are being described through oral and written testimony. It refers to a person's testimony offered to prove the truth of the matter asserted, especially evidence elicited from a witness, oral or written assertion offered in a court as a proof of the truth of what is being stated. Which of testimonial kinds of testimonial evidence? Number 1. Ordinary witness. Any person who perceived the commission of a crime and testified before the court is just considered as an ordinary witness. Also, a physician who testified in court of matters he perceived from his patient in the course of physician-patient relationship is considered as an ordinary witness. A witness can testify only to those facts which he knows of his own knowledge, that is, which are derived from his own perception, except as otherwise provided on these rules. Number 2. Expert witness. A person whose testimony concerning the investigation of crime is based on his training and experience. Hence, a physician who confirmed before the court the case of death of a victim is considered as an expert witness. And who is a witness? A person who testifies under oath in a trial or a disposition in the lawsuit. The plaintiff or defendant may be a witness. Witnesses have first-hand knowledge about matters relevant to the case, and their testimony is subject to the applicable rules of evidence. In its legal definition, it refers to a person who can perceive and perceiving can make their known perception to others may be witnesses. What is a deposition? It is testimony taken orally with an attorney asking questions and the deponent, the individual being questioned, answering while a court reporter or tape recorder for sometimes but records the testimony. Deposition testimony is generally taken under oath, and the court reporter and the deponent often sign affidavits attesting to the accuracy of the subsequent printed transcript. Deposition is a testimonial evidence. Number 3. Documentary evidence. It refers to writings, including official records or content that could speak for themselves when read by the investigators and the court. It consists of writing or any material containing letters, words, numbers, figures, symbols, or other modes of written expression offered as proof of their contents. Documentary evidence are but not limited to the following: A. Birth and death certificate. B. Necropsy report. And C. Medical examination. And that's all. Thank you.